Good morning, everyone. Welcome to the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy, and we are coming to you from She and Finney, sponsors of this great event, this great program, and this event in this program year. We're so excited that you could be with us today. I understand that we have nearly 300 people registered for this webinar, so I won't waste your time and getting to this. I'm going to talk just very quickly about some upcoming events. Next month, we don't have our monthly meeting for the Tech Alliance because it is our 36th annual Labor and Employment Law Seminar, the She and Finney's Labor and Employment Law Seminar, and it's at the Castleton Resort on May 23rd from 9 a.m. to 2 p.m. And breaking news from our marketing department is that we are within 30 seats of selling out. That is a large venue. I think we have capacity of approximately 300, and we are close to selling out. I'm thrilled that every year, really, even including the years of COVID or the years right after COVID, we came close to selling out. But every year before that, we sold out early, and we're back to sort of where we were, it seems like. And so it's a great event. Lots of timely topics from wage and hour issues to AI, from National Labor Relations Act issues to issues involving mental health in the workplace and reasonable accommodation and so on. They're just about everything you deal with or should be dealing with or may be dealing with in HR, we cover it, sort of that. Hopefully it's the breaking news and practical guidance that you'll need on these important topics. So if you haven't signed up yet, you can sign up through She and Finney's website, and that is under the events tab. We look forward to seeing you. The next event for the Tech Alliance HR Exchange is on June 10th. That is our year in review. That's when we look back over the course of the last year and the program year and provide some additional updates as we look forward into the next year. And and again, like all other Tech Alliance events, you can sign up through the Tech Alliance or through our website. One other housekeeping issue to mention is that that after this program, all registered will receive an email from Liz Tesic from our firm with the SHRM codes, the HR credits for your attendance at the program today, along with an email and a copy of the PowerPoint and recording that you can watch again at your leisure. So it's a terrific way to do this. You know, and with COVID, we went to a webinar format, and we're finding this is a very efficient way of doing these programs. And again, having the copy of the presentation and the recording, we think is an added benefit for you. So without further ado, I'd like to introduce my partner, my law partner, Liz Bailey. Liz is a litigator, a counselor, a negotiator, and investigator. Wears all those hats in her practice of employment and labor law. And she's here to talk to you today about issues with the National Labor Relations Act and National Labor Relations Board. And it's not just for unionized workplaces, it's for all workplaces. And some truly breaking news in this regard with regard to what the board is doing and issues that employers need to know about. So we are just so thrilled that Liz could be with us today, and we know you're going to really enjoy this program. Take it away, Liz.
Thank you. Thank you, Jim. And thank you all for being here this morning. I wanted to just walk through the agenda for this morning with you very briefly. We're going to start out with an overview of the National Labor Relations Act and the National Labor Relations Board on just a very 30,000-foot viewpoint of those concepts. Then I'm going to turn to recent labor law developments. And again, this is all focused on private sector labor law. And one thing you'll come away with today, to the extent you are not already aware of it, is that this is an ever-changing landscape. And there are lots and lots of developments on a, if not daily basis, on a weekly basis with the NLRB. And then I thought what might be helpful is to turn at the end of the presentation to some areas that private sector employers and supervisors may encounter in their day-to-day interactions with employees that could be, for lack of a better phrase, traps for the unwary, about mandatory subjects of bargaining, direct dealing, and social media. Some areas that folks may very well trip up on very inadvertently because they just don't know what they don't know. So I thought that might be of help to you as you walk away from today's presentation. So to start with the NLRA, the National Labor Relations Act has been around for a very long time, nearly, I think, 90 years at this point. And it's a federal law, not a state law, that grants private sector employees the right to form or join unions, engage in protected, concerted activities to address or improve working conditions for one another, or refrain from engaging in those activities. And so this means that, as Jim said, you don't need to be a unionized employer already to have this apply to you as a private sector employer. It protects people who are not in unions, but who want to form unions or want to come together and be able to interact with one another in a way that can expose the fact that they need to, engage concertedly to form a union. And the National Labor Relations Board is the independent federal agency that enforces this law. This is a bifurcated system. So it's governed by a 5-person board and by a general counsel that are appointed by the President of the United States. And what this means as a practical matter is that this is very much a changing landscape and a changing complement of people depending on who is in office as a president. Right now, to nobody's surprise, because the appointees are primarily appointed by President Biden at this point, it is a Democrat dominated organization that may or may not change depending on the next election. But what that means as a practical matter, and what makes this landscape very, I think, unique, is that in a regular court system, it's fairly rare for judges to overturn previous decisions. There's a respect for the rule of law. In this situation, it truly is very common for one NLRB to change or to overturn or to interpret the law differently than the preceding NLRB. That isn't something that people would understand, I think, intuitively. But what it means as a practical matter is that one way of interpreting these laws that affect us as private sector employers can vary drastically from one administration to the next. And it's not uncommon, and we'll see it today in some of my discussions about cases where you have one standard, new president comes in, changes the standard, perhaps back to a previous Republican or Democrat administration. So to talk about some recent labor law developments, first I'll give you some statistics. No surprise from what you perhaps are reading in the paper or just aware of on social media, that petitions to unionize have increased in fiscal year 2023, and they have increased in fiscal year 2024. As recently as yesterday, the NLRB issued some data that confirmed that the petitions to unionize are now up 35% year to year from the same time, the first 6 months in fiscal year 2024 from fiscal 2023. Unfair labor practice charges are what can be brought when one party or the other feels like the union or management is violating the law. And those have increased. They increased in fiscal year 2023. And as of yesterday, it is up 7% in fiscal year 2024 from the same 6-month first half of the year measurement period. In fiscal year 2023, unions won 76% of the elections, which is, I think, noteworthy, if not remarkable. Although union activity still is not at the level it was in its heyday, 40 or 50 years ago. Obviously, there's a lot of elections going on, and the union's been successful in a very significant way. According to Bloomberg Law, the strike activity continues to be on the rise. I think we have all seen that in the headlines Last summer in particular, there were a lot of strikes going on that were of interest on a nationwide basis. What is interesting is that the annual strikes, again, according to Bloomberg, have increased in 3 consecutive years. So that is remarkable. Most strikes in 2023 occurred not when people were trying to form unions, but during successor contract negotiations. So there was already a labor agreement, which is normally referred to as collective bargaining agreement, in place, and the parties were negotiating a new agreement, and things weren't going well, and folks went on strike. The good news is that many of the strikes were relatively short and resolved in somewhere between 3 to 7 days. So I'm going to, in the next slide, talk about, or a couple of the slides talk about some of the more remarkable strikes. But the good news is that many were in fact resolved, and folks were able to go forward and resume working together. Some recent labor law developments. The issue of joint employer remains a major focus, and I'll talk a little bit in a second about why that's important to us all. But the NLRB for a number of years has had evolving joint employer rules. That is what the NLRB looks to determine if 2 organizations are actually joint employers in relation to one another. That is, same group of workers, but the workers may say, well, I know I'm employed by one group, but I also think this other organization has enough direction and control over me that that other organization should be a joint employer. Great example, this issue came up and is coming up with Google, for instance, and one of its subcontractors, where the workers said, you know what, we think both of you are our employers. So the NLRB in 2023 had created a joint employer rule under the Biden administration that was very friendly to a finding of a joint employer. That is, it really, the rule as applied would make it easier to find 2 organizations were joint employers. And you may remember there was a lot of, I think, discussion in various HR groups and SHRM that, you know, when was this rule going to actually go into effect? It was delayed a few times over, and then it was supposed to go into effect, I believe, on March 11 of 2024. And then it was struck down by a U.S. District Court in the Eastern District of Texas, and I'll discuss that momentarily. So the concept, again, is that 2 organizations could be joint employers when together they decide terms and conditions of employment for workers. Under the NLRB's 2023 rule, which you may have seen or heard discussed, it was very friendly to the concept of people being organizations being joint employers. 2 organizations could be joint employers just by having or reserving the authority to control one or more essential functions of employment, even if that organization didn't actually exercise the authority. So that obviously makes it quite a bit easier for the NLRB to conclude, hey, we've got these organizations and they both should be considered joint employers. Why is that important to all of us? It's because if you as an employer are thinking these workers are subcontractors or they're not my employees, if you're deemed a joint employer, amongst other issues with wage and hour laws and other considerations and other types of laws, for the NLRB's purposes, it means that now you are considered someone who might be obligated to recognize and bargain with a union or with the union that is forming. And that can come as you can imagine, as quite a surprise to an organization that didn't consider those workers to be its employees to begin with. So the case that I was talking about a minute or 2 ago, Chamber of Commerce brought the case as a plaintiff, amongst others, and the U.S. District Court for the Eastern District of Texas struck down the NLRB's 2023 joint employer rule at the beginning of March. I think most folks are believing the NLRB will appeal. But the court found essentially that the NLRB's 2023 rule was overly broad and contrary to the law, and that the NLRB was arbitrary and capricious in rescinding the 2020 joint employer rule. And the 2020 joint employer rule was formulated under the Trump administration. And as we'll see, it was more conducive to a finding that there isn't a joint employment. And so what does this mean? And this is, an evolving situation for sure. What it means is that we revert, I guess we continue is probably the better word, with the 2020 joint employer rule remaining the standard. And under that rule, it was more holistic. It was talked about joint employers being joint employers if they possess and actually exercise substantial and immediate control over one or more employees, essential terms and conditions of employment. And those include hiring, firing, discipline, supervision, and direction. And again, it was a standard where the organization would actually exercise that control, as opposed to maybe they could do that theoretically, but they didn't. So under this test that remains in place, it's just going to be harder for the NLRB to establish a joint employer relationship. It doesn't mean that it can't be established. It just means that this standard tends to be a little more friendly towards employers who want to say, hey, look, we are not a joint employer of these workers. I say at the bottom of the slide, stay tuned, please do, because this has evolved many times over in the last year. And it may be under appeal, it may not, but it may be. So we may not have heard the last of this. And also, as I said at the outset, so many of the standards and the interpretations of the NLRB are dependent on the presidential administration and the complement of the people on the board and the general counsel. So who knows what the future will bring in terms of the next election. In the last year, the NLRB has issued several noteworthy decisions. And I'm going to back up for a second before I go into these, just in very broad brushstrokes. As I said at the outset, this is it is a very active landscape for NLRB developments and decisions. There are decisions from administrative law judges. There are decisions from the NLRB itself. And we'll get to the NLRB's general counsel in a moment. But there are memoranda and guidance materials issued by the general counsel of the NLRB. So to pick one, I've really just tried to select a few that were, I think, noteworthy or of interest. But I will tell you that on a weekly basis, you will have, several decisions, several guidance materials. It is evolving constantly. And it is, again, very dependent on the administration in office. So just a couple of these cases that may be of interest. And we have the citations to them for you to look them up. I will tell you these opinions can be sometimes lengthy. But the Lyon case from May of 2023, that was the issue of a discussion about when an employee is engaged in protected concerted activity, that is activity that's protected by the law, the NLRA, but the employee crosses the line with what is abusive behavior. How do you balance those two interests where somebody shouldn't be behaving in an abusive manner, but yet at the same time they're engaged in protected activity? And the general standard had been that an employer can lawfully discipline an employee if the employer could show that it would have issued the same discipline for the abusive behavior in question, without the protected concerted activity, with that being absent. And in this decision, the NLRB really noted that there may be some different standards that apply to the same analysis, depending on the abusive conduct in question. Was it an outburst to management? Was it social media postings? Was it conversations among employees? Was it, on the picket line? And so what that means, I think, at least for this moment for employers, is if they are looking to discipline an employee who's engaged in protected activity because that person really they feel crossed the line, they would want to work with their legal counsel and look carefully at what was the abusive conduct in question and in what context was the protected activity, what context did it occur. The Atlanta Opera case, again from June of 2023, this is a more employee-friendly independent contractor test. So what this means is, as a practical matter, the NLRB is going to be under the standard able to come to the conclusion that an employee, a worker is an employee as opposed to an independent contractor. Before, in the Trump era, the test really focused heavily on entrepreneurial activity as being a significant factor to look at. And this test makes clear that no, it's really a holistic look at various considerations, and the entrepreneurial activity of the worker is not the primary consideration. The Stericycle case, that is a case that analyzes whether an employer's work rules unlawfully restrict protected employee activity. And these analyses aren't, it's seldom that an employer puts a policy in place that prohibits union activity. I think we are all well beyond that and understand that that would be prohibited and inappropriate. But really the focus is on whether some work rules that the employer believes it has a legitimate business interest in having have the effect or the consequence of restricting protected union employee activity. And it could be, it simply chills the activity. It makes somebody less liable to think that if they were doing something, that it would perhaps be subject to discipline by the employer. And therefore, they didn't do something that they otherwise would, that would have been considered protected activity. And lastly, we look at the Intertape case. This is probably a little bit more interesting to lawyers than anybody else, but it just goes through an analysis that even entirely circumstantial evidence can be probative of retaliation in retaliation cases. Again, something just to be aware of, retaliation claims in any setting, be it under the NLRA or be it in what we all may be more used to in terms of discrimination laws, are very challenging. And sometimes there could be circumstances that become very, very fact specific to get to a finding of retaliation or a finding that no retaliation exists. And this concept of talking about circumstantial evidence, I think, gives one pause in terms of looking at the facts and determining like what would satisfy a retaliation standard. Now to get to some recent law developments with the general counsel. The current general counsel, Jennifer Abruzzo, has been in place for over 2 years. General counsel has been, I think, remarkably active and proactive in issuing memoranda and in her initiatives, and takes a very plain-spoken approach to views on various issues. So if you are interested, the NLRB's website is very helpful. It's very well organized, and it does have general counsel memoranda. Goes by dates, but it also has a brief explanation of the topics. So if you are interested to scroll through at some point, you can really see a pattern where there has been a lot of activity by the general counsel since she became appointed. One memo that came out last May was about non-compete agreements. And the general counsel doesn't say that they can never exist, but she focuses heavily on the concept that a true non-compete agreement where you can't go to work for a competitor has, in her view, a chilling effect on employees' ability to be able to act in a protected way under the NLRA. It might make them feel that they don't have any bargaining leverage because they can't go to a competitor. It may make them feel that they can't go to a competitor and take a bunch of employees with them and have that leverage. And so her viewpoint was fairly stark about this when it comes to non-compete agreements. And when she was analyzing this in the memo, you will see that there really was a focus on true non-compete agreements where you are prohibited from competing, from going to a competitor. And she completely disfavors those types of arrangements, fair to say. However, she does recognize that there can be instances where an employer does have a legitimate business interest. And I think although she may take a very broad brushstroke about this, she does make a distinction between non-compete agreements and non-solicit or confidentiality agreements. Back in March of 2023, she issued some guidance about severance agreements. And really, my third bullet point probably best marries up with this memorandum. The notion really is that, yes, you can have severance agreements, but her viewpoint is that you have to be very measured with them in terms of provisions about non-disparagement and provisions about confidentiality, amongst others. The idea being that you don't want the language of your severance agreements to be so broad that as a practical matter, it would prohibit an employee or about to be former employee from engaging in protected union activity, or it would prohibit a former employee from discussing matters that would fall under the rubric of protected activity, terms and conditions of employment. So it's important. I think probably everybody out there, if they're working on severance agreements, they usually do so with their in-house counsel or their regular counsel. And I think fair to say your counsel have been keeping track of this and trying to be very measured in their language, and also try to make very clear that these agreements are not intended to impede or interfere with anybody's rights under Section 7 of the NLRA, which is those protected rights to employees or to people who are trying to organize unions. Some other recent developments include, as you may well be aware of, over the past 6 months, we have all seen some very notable collective bargaining agreements being entered into, sometimes after strikes or labor unrest. We all remember the Screen Actors Guild has been on the picket line. And I think everybody had a hiatus from new streaming or TV content last summer when those labor unrest situations were going on. United Auto Workers and UPS. And I think we all remember over the course of the last few months when UPS was in its labor dispute with its union, the Teamsters, that, there was a real consideration of how, even though we're not directly involved, how it could affect all of us in terms of, packages, in terms of our day-to-day lives. Recently, right here in New Hampshire, our New Hampshire attorney representing the Dartmouth College men's basketball team's union was able to successfully argue that the men's basketball team was, in fact, should be considered employees of Dartmouth College and should be allowed to unionize. And those players did vote. It wasn't unanimous, but it's a small group of individuals, as you can imagine, and just being a basketball team, but they did overwhelmingly vote to unionize. I understand that there are appeal efforts going on now, and the focus really was, I think, probably direction and control type issues, and an employee type analysis. But that was interesting to us here in New Hampshire. It struck pretty close to home. And then we've seen strikes over the last year as well that were noteworthy. Forbes and United Auto Workers in particular, that I think we're all, highly attuned to. And to talk a little bit about mandatory subjects of bargaining, why I wanted to talk about these things a little bit with you is that in many instances in employment law or in labor law, folks wind up getting into some hot water, not because they think they're doing anything wrong, but sometimes even because they think they're doing something that could be favorable or could be helpful to the organization or helpful to employees. And when I talk about direct dealing in a minute, it's also going to be premised on the notion that if you have a union as an employer, or if a union has been recognized, even though you might not have your first collective bargaining agreement, if a union has been certified, you're obligated by law to bargain with the union in good faith about wages, hours, and other terms and conditions of employment. So it's not just money, it's not just the time you work, it's other terms and conditions of employment as well. That could include discipline, that could include leaves of absence, work rules, etc. And to bargain in good faith doesn't mean you need to reach an agreement. People can't be forced to agree with one another, but it does mean that you need to meet and at reasonable times and reasonable manner and places, and negotiate with one another and not unilaterally make decisions. So that's the concept that we're going to talk about here, and where people can run afoul of it by accident is people just, and I'm not picking on supervisors, but supervisors or managers who might not be necessarily directly involved in organization's interactions with the union. They might not be part of a bargaining team. They might not really have been involved directly with some issues, not appreciating this obligation. So to turn to the next slide, what do we mean by mandatory subjects of bargaining? Mandatory means what it says. You got to bargain over it. But you can't unilaterally make changes about mandatory subjects of bargaining, such as changes to wages, bonuses, vacations, holidays, sick time, leaves. You can see how broad this is. And I'm going to go on to the next slide. Hours of work, lunch breaks, rest breaks, health insurance, which is obviously a big item, job postings, seniority, bumping, layoffs, or subcontracting or transfers. So those are things that are issues that employers deal with in many instances every day. Some workplaces are more seniority driven or job posting or layoff or bumping, their policies and their protocol are more well developed because they do have existing collective bargaining agreements. But it's just something that you can't change without bargaining with the union. And, I don't mean something that is, perhaps you give somebody, they came back a couple minutes late from a lunch break. I'm not talking about that. And the supervisor says, hey, that's okay, don't worry about it. I'm talking about really making fundamental changes to these types of issues. There would need to be a discussion with the union to do that. And then I'm going to turn to direct dealing. And this is something that I have seen be an issue with employers. Again, not because employers were intending to do anything wrong or illegal, but because they just didn't have it in mind at the time. And it might fall under the category of no good deed goes unpunished. So what the concept is drawing back to that slide about mandatory bargaining. The idea is if an employer is obligated by law to bargain with a union about mandatory subjects of bargaining and interact with the union, about bargaining issues and about terms and conditions of employment. The employer can't bypass the union to deal directly with employees. And how does that come up the most? Sometimes it comes up because an employer is actually kindly and they want to do positive things for bargaining unit members. They want to do good things. They want to add a benefit. They want to maybe we're going to have a pay stipend, or we're going to have some bonus payments. We're going to have a sign-on stipend. We're going to have incentives, things that are really good for the employees and for the employer. And that may be very well intended, but the unintended consequence is that by going directly to the employees and ignoring the union, the employer essentially is undermining the union. Why is there a need for a union if I'm an employee and I have a really great employer? Why am I paying these union dues? Why do I need a union? My employer's great and they're going to do these nice things for me. So that's one issue. And then by doing that, I think unions understandably are very sensitive to being bypassed, even if it's for good reasons. So a union is going to be, I think, relatively quick to consider an unfair labor practice charge against an employer who does that, because they really do need to make sure that an employer is appropriately dealing with them and not direct dealing with the employees. So that does get it's a issue that can be very well intended, but really turn into something where a union feels, even if they have good relations with the employer, that they do need to file a ULP in order to protect their rights. What I think the norm would be is that, there could be a real alignment with the employer and the union about issues where the employer wants to do something more than they're obligated to do for the employees. So it could well be that by, dealing appropriately with the union about some positive developments, what will happen is it should not, be a major issue in terms of working with the union to implement those changes with the union's agreement and the employer's agreement. And sometimes those things can be accomplished by what's called a memorandum of understanding or a memorandum of agreement. And there could be other instances where an employer wants to do something that the union doesn't really appreciate or want and doesn't feel appropriate. It's, a good thing for its employees. So all of that being said, that is, something that you would need to go to the union to talk about. And the next slide, social media traps for the unwary. This is something, I think social media, many employers out there who've not dealt directly with union issues have grappled since social media came around, that essentially it is a challenging concept. It's a challenging medium for employers, because employers, I think fair to say, do not want to be involved in employees' personal lives and be overly intrusive. They don't want to look like they're the police of employees' personal lives. But the issue comes up when a problem faces an employer. Happens a lot in discrimination or retaliation settings, where an employer learns of a social media post that is problematic because it's harassing or discriminatory or retaliatory, or it raises some issues concerning the employer and the, whether the employee or former employee appreciates the employer or is very critical of them. Very easy when, discrimination, harassment, that's obviously inappropriate, and that's something that employers need to address. I'm not really talking about those situations here for our purposes of today, but fair to say that employers and supervisors, when they might be the first people to be aware of them, you need to be very cautious about overreacting to social media posts, because they become very dependent on what is being said, what are the words, And could those words be fairly construed that the employee in question is exercising, the employees are exercising their rights under Section 7 of the NLRA by making anti-employer postings? Maybe they are talking about terms and conditions of employment. Maybe they're commenting on how, boy, my employer stinks. They pay an awful wage. The insurance is awful. Their rules are ridiculous. That activity could be protected under Section 7 of the NLRA, even though it might seem to be negative, it might seem to be insulting, it might seem to be defamatory. The question really is this statement, are these conversations for mutual aid and protection, or could they be viewed as for mutual aid and protection? And that many times is not an easy thing to analyze for supervisors or for HR representatives. And many times I will say that I've had, folks call me and say, what do you think about this statement? And we really work our way through it and then determine what, if anything, and I say, if anything, is an appropriate response, or if no response at all is really the best thing to do. But it's very easy to get worked up. It's very easy to get upset when you as an employer are being insulted or chastised, and particularly if you feel that it's not accurate information. So the point here is, please, please, please be just aware of that this could be a problem. The format is obviously very difficult. It gets out to a lot of people. And when you as an employer feel insulted or that the information is inaccurate, that can be a real challenge to employers. But you just do need to bear in mind that looking at the words, looking at the context, looking at the dialogue and the discussion, just please bear in mind that within all that, there could be an instance in which somebody really has actually, whether they knew it or not, engaged in some activity that the NLRB would consider to be protected activity. Let's see here. And so I am at the end of my my presentation today. I'm trying to see if we've got some questions. And hello to Lee. Then Lee asks a great question. I'm sure the group can see it. Are you able to tell employees that you cannot do nice things, XYZ, until it's negotiated with the union so that the union members know? I think, I have to answer that question needing to know more context about it. My suggestion would be that you wouldn't just go and tell employees that in a vacuum, because I think that essentially is direct dealing with employees in and of themselves. If somebody asked you affirmatively, I think you could be saying, oh, we have our discussions with your union. We're going to be happy to discuss issues like this with your union. You really don't want to kind of trip into an issue where you are direct dealing with employees. So it's, from my perspective, I think it helps employers to be thoughtful in thinking through what it is they want to do and how they want to do it, and thinking through the various consequences and what it means to them and to the organization, and then reaching out to the union and having some discussions about it. And hopefully, when we are talking about nice things and great initiatives and things that make it a better workplace for everybody, I think unions are very often open to that, enthused about that, might have some great ideas or some concerns or questions that might make it a better product, but generally will not get in the way of those types of initiatives. Everybody may have a different experience, but the bottom line is that you don't want it to be that you are really having meaningful side discussions with employees about wages and terms and conditions of employment and new benefits and new initiatives, and you haven't done that with the union. The union has been certified as the exclusive representative of the bargaining unit. And therefore you have to deal with the union, and that's a legal obligation. And many employers who are seasoned at having unions in the workplace, it is a very good working relationship, and it is a very easy dialogue and an easy ability to get in touch with one another to have those discussions in a meaningful way. And thank you, Lee. I don't see any other questions at this point, and I am happy to answer any that anybody has. But I recognize that many of these things are very fact specific to you and to your workplace. A couple of the takeaways are that really, even if you're not unionized now, you have to understand that these laws do apply to you, and they're there to protect people and their ability to form a union and not just be in a union. That your policies and your agreements need to, have this law in mind as you're formulating them. And if a union is formed and certified, you do need to deal with the union and hopefully come up with solutions to problems and be good working partners with one another. I've seen that happen, and it's a great thing when it does. So I thank everybody for their time today. I'm going to advance the slide. And I would be remiss not to say Liz Tezek was going to give me a reminder if I didn't. But this is an approved course. And please feel free to reach out and get this approved through this information. Liz Tezek also has this information available if you need it, if you forget and need it at another date. And I'd just really like to thank everybody for being here today. I appreciate your time. And I'm happy to talk further if you have any questions that you weren't feel comfortable about online. Happy to talk further. And thank you very much.